the verdict coming down from what the court and we have referred to as a tainted junkyard.
All right.
First of all, Judge, it would be the state's position that these defendants are not in the same position they were prior to January of this year, particularly Mr. Vandenberg, pardon me. But given the changes in the bonding statutes over the past few years, where the release of their liability or their obligations to the court have changed back and forth, to where now it's that, well, pending the guilty verdict in a case, not necessarily this, but in a case, that they shall remain on the bond but may not have a forfeit granted. So if we're looking at it from that standpoint, I think we're in a little different position. It would be the state's position that I think the court would be within its rights to hear from the bonding authority, someone in authority, to see what their position is, to have them under oath on the record that, number one, are they going to charge an additional premium? Are they understanding they would be liable in the event of any forfeit and would not be entitled to take advantage of the post-guilty non-forfeit position? So that's one issue. It's just, I think, for the clarification and protection of the system and the court to hear from that, or hear about that. And when I submit that they are not in the same position, because one of the things the court has to look at in bond, and the state did file a motion to modify the terms of release, the state feels as though bond in this matter should be increased based upon looking at what has occurred. And in the statute, the court looks to, among other things, obviously contacts to the community. That's a plus for Mr. Beatty, a minus for Mr. Vandenberg, I submit. But the likelihood of conviction, we know what that is from the proof. Maybe these defendants didn't know that at the time, but I submit now they know the consequences. Immediate bond revocation and penitentiary sentences. Submit that does increase the likelihood of flight. That knowledge that they now have, whether they had it before and didn't comprehend it, or maybe they did, but I submit taking that likelihood of conviction, the increased risk of flight based upon the consequences that will come, submit, in all likelihood from the retrial, that bond should be adjusted accordingly. With respect to Mr. Vandenberg, aside from his no ties that I know of to this community, found out during the gathering of the pre-sentence report, and this is something I would like to question his bonding agent about, whether he knew that Mr. Vandenberg had been charged with additional offenses while on bond. I think that's a circumstance that might alter. So, based upon that, I think we should hear from the bonding companies, and then we would ask the court to modify these conditions accordingly.
All right. Well, we have the representatives from the bonding companies here, so I'll be happy to hear briefly from each of them. So, the representative from Free at Last, please step forward.
Vice Clerk, sir, raise your right hand.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Judge Watson.
Who wants to examine it?
Would you state your name for the record, please?
Mario Hamburg.
Mr. Hamburg, which bonding company are you associated with?
I'm a co-owner of Free at Last Bonding.
Okay. And since September of 2013, or in I believe it was September of 2013, were you approached about being a bondsman in assisting with the bail for Corey Beatty?
Yes, sir.
Okay. And did you, and you were one of two bonding agents, is that right?
Yes, sir.
And who is the other?
Nashville Bonding.
Okay. And Mr. Beatty, Mr. Beatty's family paid the fee agreed upon for the bail, is that right?
Yes, sir.
Okay. And as of, with the order that came down yesterday, are you willing, is your bonding company willing to stay on Mr. Beatty's bond if reinstated?
Yes, sir.
Okay. And to remain a surety for Mr. Beatty?
Yes, sir.
And let me ask you while you're here, for a period of about 12 months or so, the judge asked Mr. Beatty to sign in at your office, did he not?
Yes, sir. He come over every Monday and signed in.
Okay. And did he miss any dates that you're aware of?
No, sir. Sometimes, yeah, he would always come on Mondays. He would be coming from the gym, come over and sign in.
Okay. All right. Judge, do you have any other questions?
The state may have some questions.
So I take it, you do not intend to charge any additional premium?
No, sir. I would like juror number 9 to pay us our fees.
Well, that's.
Yes, sir.
But as far as, you heard what I said, although I know I had my back turned to you, that about being liable in the event of a forfeit, that this case would go back to pending as opposed to taking advantage of the not being able to have a forfeit taken if it was a conviction. So you understand that?
Yes, sir. Sure do.
Okay, and so no issues with that?
No, sir. This is what I do every day.
Okay. That's all I have.
All right, we have Nashville Bonding representative here as well. You may step down. Thank you. Come forward, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Would you state your name for the record, please?
John Guthrie,
Mr. Guthrie, you are a owner in which bonding company?
National Bonding Company.
And in, I believe it was September of 2013, did you, along with Free at Last, and your bonding company, along with Free at Last, sign and take on Mr. Beatty's bond as a surety for Mr. Beatty?
I'm not sure of the exact date, but that sounds accurate.
Okay. And obviously, as of the ruling yesterday, we're here on a motion to reinstate, and we had a discussion out in the hall, and you did state that you would like Mr. Beatty's family, whoever signed as sureties, to complete and re-sign any paperwork. Is that right?
I don't want to have the bond reinstated, no. We'd be willing to go through making the bond process again, if that's what the court wanted, but it's not going to be with our bonding company.
Okay.
We don't have an objection with them being on bond, but we don't want to be reinstated on the bond.
Okay. So is it your testimony then that you want him to go through the process and have to pay an additional fee?
No, not to us.
Okay. Okay. I don't have any further
All right.
questions, Your Honor.
Questions from the state?
Sure exactly where it is this, but you split the bond with Free at Last, correct?
Correct.
Okay, so was that a 50-50?
I believe so at the time. It was with one of my agents, and
Okay.
it's been a while.
Okay. So whatever that split was, you want out of your part of it?
Correct.
And that Mr. Beatty then, assuming the bond were to remain the same, or whatever the bond that amount would have to be reposted through a different bonding company
Correct.
or some other method. So, okay, thank you. That's what I thought.
All right,
Thank you,
may
General.
step down. All right, Mr., I forgot which bonding company you're with. Come forward. Espinosa, yeah.
State your clerk, sir, raise your right hand.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Mr. Espinoza.
Morning.
Would you please state your full name for the court and your title with your company, please?
George Espinoza, Round the Clock, Around the Clock Bell Bonding Company, and I'm a co-owner.
Your co-owner. And your other owner is?
Conley Brown and David Hood.
Okay. And you've discussed what we've talked about here in court this morning?
I did.
And that's the reinstatement of Mr. Vandenberg's bond, is that true?
Yes, sir.
Okay. And you heard the state mention something about some new charge out in California that they have brought up this morning. You heard them talk about that.
I heard it this morning, yes.
And were you aware that that was some misdemeanor charge out in California where he was written some citation? Were you aware of that?
I wasn't, no, sir.
Okay. And does that concern you?
If it's a citation misdemeanor, I'm not concerned with it.
Okay. And you and I spoke also about a bonding statute which allows the bonding agency to receive 10% of the 10% of a fee.
Correct.
Okay. And if your company requires that, we spoke about Mr. Vandenberg paying that to you. Is that true?
We did.
Okay. And do you have any issues whatsoever so long as your terms are met with any additional fees whatsoever to be reinstated on Mr. Vandenberg's bond?
Correct.
You do not have
No,
any
I
issues?
don't. I do
None
not.
at all?
None at all.
Okay. And you've never had any issues with Mr. Vandenberg during this course of this?
No, no issues.
Okay. Thank you, Your Honor.
All right, cross-examination.
Mr. Espinoza, is it part of your bonding contract that a person notify you of any contact with law enforcement, new arrests, new citations, anything of that nature?
Most of the time, it's a felony, or they're going to jail.
Okay. I'm talking about the contract, not what
Contract.
most of the time you do.
It says on there that if they get arrested, it don't say nothing about a citation.
So you don't know whether this is a citation or not, personally, because you've never heard about it.
I never heard about it.
And certainly not from Mr. Vandenberg.
No, sir.
Okay. Now, do you have any way of monitoring where he is in California, that is by GPS or any type of,
No.
other than calling and perhaps saying, where are you?
Just him contacting us, to let him know, but no GPS, no.
That's all right.
All right, you may step down. Was there another bonding company involved in this?
No, Your Honor. Mr. Espinoza, let me take the entire process.
All right, does either side want to be heard further?
Your Honor, we are, first of all, requesting that Your Honor reinstate the bond based on the arguments made previously. With regard to the Nashville Bonding Company, we do believe that the court has the ability to order them to stay on the bond, and would request that you do that. In the event you cannot and will not do that, Your Honor, we respectfully request that you consider reducing Mr. Beatty's bond to 1/2 of what it was, which Free at Last Bonding has been the surety on the entire time. We believe that would be an appropriate remedy in this case in light of Nashville Bonding Company's decision to not want to continue, but we do believe Your Honor has the ability to order that if you have the discretion to do that.
All right, Ms. Bowles?
Very briefly, Judge, please. Just a couple of things in regards to the state's contention that now Mr. Vandenberg is aware of the consequences. He was aware of the consequences before this matter went to trial. So to suggest that Mr. Vandenberg wasn't aware that if ultimately convicted of these allegations, that his bond would immediately be revoked and that he's facing substantial time of incarceration, that's misplaced. He was definitely aware of that. He chose to show up each and every time he made that decision, and he'll continue to make that decision. Judge, as it relates to this offense that the state says they learned about in the pre-sentence report, I believe if the state were to be called as a witness, that discussion took place long before the pre-sentence investigation report. They were aware that there was a citation issued. It came in the form of a letter to Mr. Vandenberg. It's my understanding that that case is set for dismissal in the state of California. Mr. Vandenberg has complied with all conditions of release. Mr. Espinoza does not have any issues with Mr. Vandenberg. This court, should this court ask Mr. Vandenberg to wear a GPS monitoring device or to do place any other condition on him, he would be more than willing to do that. However, we feel like any other conditions placed upon Mr. Vandenberg prior to, that were not placed on him prior to this unfortunate juror number 9 that has caused this mistrial issue, I think would be hard pressed. But at any rate, we believe that the statutes and the testimony that's been presented here today, this court has the authority to reinstate those bonds and that Mr. Vandenberg be released subject to those conditions, Judge. Thank you.
Anything from the state?
Just briefly, Your Honor, in the sense that the court obviously has seen the state's concern about this matter and understands that, as well as, I think certainly national bonding, it was within their rights to, given the events that have occurred, to not wish to stay on his bond, and certainly it should not be reduced. The state submits that they should both be increased substantially, and with all due respect, whether about Mr. Vandenberg knew or didn't know, that anyone, I think, who saw the look on his face when he heard the word guilty might have surmised that he didn't see it coming, but in any event, I submit he should now, and that's the concern.
All right.
And before, I know while I'm up here, at some point, not necessarily today, well, the court's in the middle of a jury trial, but I think we probably would need to have this matter on the next week or two to sort out who's representing who and pick a trial date and do all those necessary things.
Unless you want to do it today. I mean, we're
Well,
going to start our trial back,
Well-
but you can meet with one another and try to come up with a date if you'd like to do that.
Well, we can try to do that. General Thurman's out of town this week, so I'd like to sort of get him in the loop, but to the extent that we can do that.
And to address that, Your Honor, we need to make some arrangements with the family, repetitive events that have taken place, so we need to talk to them about the trial and make
All right.
arrangements for that.
Well,
We'll have some time for it.
And that was kind of what I was understanding about whether the council was going to be retained.
All right, very well. I mean, we can set it on another date, that's fine. I know the state wants a trial date as soon as possible, and we can do that. We can accommodate you on that. We could have to, of course, move some other things around, but we can do that. I only have two basic questions. First is whether either of the defendants have a passport, and if they do, where are those passports?
Mr. Beatty does not have a passport, Your Honor.
All right.
Mr. Vandenberg does have a passport that is expired.
Okay, it's expired. I would like, I need to see it anyway.
I don't see how at his age he could have a passport if it's expired.
Well, if he got it at a very young age, it could.
But it should be submitted.
If I may say this, it was in the dorm room, and that was all taken out.
You don't have it in, he doesn't have it in his
He
possession.
does not have it in his possession, doesn't know the whereabouts of it, Your Honor.
Okay. If you find it in any
Sure
way,
do.
please turn it in.
We'll tender to it.
Now, let me just deal with each one. First of all, Mr. Beatty, there hasn't been any testimony at any time when Mr. Beatty has violated any conditions of his bond. Both of them have very substantial bonds, so the liability for the families would be great if either of them were to try to skip bond in the event that they are reinstated to bond. Given all of that, I think that I will reinstate Mr. Beatty's bond. I will require him to wear GPS during the pendency of this matter, and he will also have to check in, as he has done in the past, weekly with his bonding company. Now, with respect to, and the bond would be the same for Mr. Beatty, by the way. I'm not relieving Nashville bonding. I don't think they've given any grounds for being relieved, other than because although he was convicted in that first trial, that's basically a nullity at this point. With respect to Mr. Vandenberg, because he is out of state and he did pick up an additional charge, albeit a misdemeanor, I'm going to increase his bond by $50,000, and I'm going to also require him to get on GPS. Now, the logistics of that, I'm not sure how that's going to work, but I think it can be worked out. So those are going to be the conditions. He will have to check in weekly, that is, call in weekly to the bonding companies, and the bonding company, that is. And I think that's going to be it, I believe.
Your Honor, I know last time Mr. Beatty is indigent, and we will be asking Your Honor to waive the fee.
Well, you know, I can't at this point. I may at some later point, but right now I'm not going to waive that fee. It's not a substantial fee, but I understand it's something that has, you know.
Yes, Your Honor. We'll if it becomes a bigger issue.
All right. All right.
Mr. Vandenberg, could request the court to be allowed a period of maybe 30 days since he's going to have to travel to California, and probably have to make arrangements with some firm out there to get that monitoring in place. We can have some time to get that done.
Well, I mean, I'll give you a reasonable amount of time. I don't know about 30 days, but a reasonable amount of time. I don't know whether he's in a position to make that increased bond today or not. I don't know. All right. Okay. Anything further from either side?
What would be a reasonable amount of time, just so Mr. Vandenberg and Mr. Perez is aware, if he were to be able to make that bond, is it 14 days from the day he makes bond to have that GPS in place? Is that a reasonable amount of time for the court?
That's fairly reasonable.
14
Yeah.
days, just so we have some parameters. Thank you.
All right. All right. Thank you. I'm going to take about a 5-minute break for everybody to clear out, and then I have a couple of things left over from 9 o'clock. I'm going to take those up when I come back, but I know a number of people want to leave out, so 5-minute break.
All right.